Good afternoon, everyone, and thanks so much for joining us today. I'm really glad we could bring this program together. For those who may be new to the AAJLJ, we're part of a global network of lawyers and jurists focused on advancing human rights, supporting democratic values, and addressing issues affecting the Jewish community. Bringing together thoughtful, timely legal conversations like this is very much at the core of what we do. Before we begin, I also want to take a moment as we approach Passover to wish everyone a Chag Pesach Sameach. Passover commemorates the exodus from Egypt, the journey from oppression to freedom, and remains central to how we understand ourselves as a people. It's both the story of liberation and a reminder of the struggles Jews have faced across generations, and of course, the resilience that has carried us forward. These themes feel especially resonant this year. We hope you are able to spend meaningful time with family and loved ones at your seders, and that the holidays bring a sense of reflection and renewal. At the same time, we continue to hope for a favorable and lasting resolution to the current war and for safer and more peaceful days ahead. I will also note that our AAJLJ annual meeting will take place this Sunday at 6 p.m., and we would very much like to welcome you there via Zoom. Turning to today's program, we will be discussing Sander versus Westchester Reform Temple, a case that has concluded very favorably after going all the way up to the Court of Appeals. This case raises complex and important questions at the intersection of employment law, religious autonomy, and free expression. We're very fortunate to have Michael Reed with us today. Michael is a partner at Yankwitt LLP and represented Westchester Reform Temple in this matter. So we're especially grateful to have his perspective on the case and its broader implications. Quick note before we begin, today's program is being recorded, and we will leave time at the end for questions, so feel free to write those in the chat. Thank you again for being here, and with that, I will turn it over to Michael.
Great. Thank you so much. Thank you for that very kind introduction. I'm excited to speak with you all today. I recognize my friend Arthur Traldi, so it's good to see you. Arthur is one of the reasons I joined the association. I work at a firm called Yankwitt. We're a boutique litigation firm based in Westchester. Everybody is either a former federal clerk or big law lawyer. I used to work at Kirkland & Ellis, and my partners used to be federal prosecutors, some of them. So we do a lot of work, state and federal, civil and criminal, here in Westchester and in New York and in New Jersey. This is the first time I'm giving this talk, so I hope it's good, and I hope I get some feedback. If people think that what I have to say is of value and interesting, I hope you'll let me know if there are other places that I can share the talk. And also, since I'm new to the association, I hope that people reach out afterwards. I'd love to get to know people and talk about the association and our practices. All right, so I'm going to be speaking for a bit today. It is meant to be informal. There's going to be a PowerPoint, and I'm not going to be able to see people, but if you have something, you can put in the chat, and I'll take questions as we go and after. All right, so let me share my screen. Oops, no, that didn't work. Okay, can you see? Somebody give me the go ahead.
Yes.
It's good. Okay, good. All right, so today I'm going to be talking about this case, Sander versus Westchester Reform Temple. It's a case that I worked on for several years. It spanned 3 different courts, and I'm hoping people know the basic outline. Well, I represented a synagogue in Westchester, and the synagogue hired a teacher at its religious school. She was fired, and then she brought a lawsuit against the synagogue and some individuals. I'm going to talk today a bit about the parties who were involved. I'm then going to talk about the facts of the case. I'm going to talk about the legal principles at issue, and then talk about the litigation, which spanned 3 courts. All right, so let me begin with the parties. So the plaintiff in this case was a person named Jessie Sander. She's shown here. She is the founder of a group called Making Menches with her friend from childhood, Alana Lipkin. They have a website. They bill themselves as a home for queer, anti-Zionist, Jewish ritual, radical education, and community. They have a web page, and it describes their origin story. They apparently grew up together in the Hudson Valley. They started doing presentations at their synagogue on anti-racism in 2020. And then they write as follows: in May of 2021, we decided it was unaligned with our values to remain silent on anti-Zionism. So we published a blog post making our values clear. Our temple never worked with us again, leaving workshops in the midst of being planned in the dust, and congregant members we grew up loving, sending us emails telling us how we were misguided, wrong, or not Jewish anymore. The blog post led to Jessie being fired from her job as a Jewish educator. So remember that term, Jewish educator. Jessie ended up suing the synagogue that fired her, and the lawsuit is still ongoing, end quote. So that is the webpage of this group. The lawsuit is now over, and Sander did not win. There's a values statement also on their webpage. They make clear that making mentions of this group is a home for anti-Zionism. They say that that is their hard line. And they write, quote, "We know what it is to feel the betrayal of being part of normative Zionist Jewish institutions and then being rejected by them. We know what it is to come to anti-Zionism because of the values that these institutions taught us and then be told we are bad or wrong or misguided or not Jewish anymore. The trauma and pain is why we fight for this space to exist so we can all practice the Judaism we love." All right, so that is the plaintiff in the case. And the defendant in the case, who we represented, is Westchester Reform Temple. It's a wonderful congregation in Scarsdale, New York. It's got a fantastic senior rabbi who has become a friend. He actually went to my college, Amherst College. We don't produce many rabbis, but he's fantastic. There was another individual defendant, Rabbi David Levy. The senior rabbi is Jonathan Blake. The other individual defendant is David Levy. He's no longer at the synagogue, and the executive director, Ellie Kornwright. All right, so those are the parties. Let me talk a little bit about the facts right now. So in 2021, Sander went on to this website. It's called jewishjobs.com, and she found a position and applied for it. She ended up getting the job. Here's her offer letter. This is one of the exhibits in the case. So you can see it's from Westchester Reform Temple. People refer to it as WRT. So this is dated May 10th, 2021. And you can see that she has been offered the job of full-time Jewish educator. So not just a full-time educator, a full-time Jewish educator. And the offer letter goes through her duties. She's going to be a teacher in the Jewish Learning Lab, which is the religious school of the congregation. And you can see here in the mission statement that the mission of the school is to kindle a lifelong love of Jewish learning and living. The purpose is to support the development of a strong Jewish identity rooted in Jewish heritage, nurtured by the study of Judaism, and leading to a life guided by Jewish values, and to create enduring and joyful Jewish memories, bringing Torah to life and inspiring Jewish dreams. As I said, the position was in this religious school, a Hebrew school of the synagogue, the Jewish Learning Lab, and she's going to report to the director. The offer letter goes through her duties. They include teen programming, and I want to highlight a few things. She's supposed to guide the development of all programs. For example, Shabbat, Havdalah, and other teen-led events and initiatives. She's supposed to develop and run teen social action activities and attend all 9th grade confirmation track 1 experiences. Her responsibilities include teaching 15 hours a week. She's going to do chavruta, one-on-one tutoring for learners. She's going to do pre-Bima tutoring with 7th graders, and she's going to do a Saturday morning Parsha with the 6th graders. The offer letter says that her employment is going to be at will. In New York, New York is an at-will state, and under the at-will law, people can be fired for any reason or no reason whatsoever, with some exceptions. And we're going to address whether or not a particular law was an exception in her case. This is her signature on the offer letter, you can see that it's dated May 11th, 2021. So the offer letter is dated May 11th, 2021, May 10th, 2021, and signed May 11th. All right. 9 days later, on May 20th, so this is after Sander had been hired, but before she started work in July. On May 20th, she and her co-creator of Making Mentions, Alana Lipkin, publish a blog. And the title is Israel Won't Save Us, Moving Towards Liberation. The Israel is written with a lowercase I, that's deliberate. And throughout the blog, they continue to refer to Israel with a lowercase I. They say in this blog that they are going to speak out, quote, "We must speak out against Israel," again, the lowercase I, "Israel's most recent attack on Gaza," end quote. They referred to Israel as a regime of legalized apartheid, quote. They refer to the American-Israeli military-industrial complex. They say that Israel is committing a genocide in Palestine. They say that they are white American Jews who were raised to support Israel, and they, quote, "refuse to perpetuate one-sided narratives." They are calling for American Jews to, quote, "revisit their educational philosophy and curriculum about Palestine and its history." They say that this blog, their organization, has a project of furthering tikkun olam, repairing the world, the ethics laid out in Pirkei Avot, tzedakah, justice, and emet. They make clear that they reject the notion that Zionism is a value of Judaism. Remember, the Making Mentions hard line was anti-Zionism. They say that the struggle, quote, "towards dismantling white supremacy is one that makes the world safer for all marginalized groups." So they're charging Israel with engaging in white supremacy. They talk about what they view as an American funding of Palestinian genocide, and they close as follows. They say, "Our anti-Zionist journeys, while difficult, have been nothing short of essential to strengthening our passion for Judaism." End quote. They say, quote, "We too were once judgmental of Jews who criticized Israel, assuming we were more deeply connected to Judaism and more highly educated. To those Zionists, we wish you an anti-Zionist journey as transformative as ours," end quote. So this is the blog they posted in May. Sander, remember, had been hired, but she had not started working at the synagogue. She started working at the synagogue in July, and she was not there very long before she was fired, at which point she brought after she was fired, she brought a lawsuit that got a lot of public attention. The lawsuit was featured in the New York Times. It was also in the Jewish press. It was in the Forward, the Times of Israel. It was all over. The lawsuit asserted a claim under a law called the Recreational Activities Law in New York. And I want to talk a bit about that law. I also want to talk about the First Amendment, because that featured in our case very heavily. That was one of our defenses, and it's ultimately the defense that prevailed in the New York Court of Appeals. I should just say, people who are listening might be from different places. In New York, the Supreme Court is the trial court. That's where we started. And then we went up to the intermediate appellate court, that's called the appellate divisions, the second department, where we were in New York. And then we ended the case at the New York Court of Appeals, which is the High Court of New York, equivalent to what other states would call the Supreme Court. Right. So we had 3 levels, but it all started in the Supreme Court, and it started with her complaint and her claim that the synagogue had violated the recreational activities law. All right. What is that law? It was passed in 1992. This is the second or the third time it had come up. It was vetoed previously because it was too broad. And what it says is as follows. It says that an employer cannot fire an employee because of their, quote, "legal recreational activities, including cannabis in accordance with state law, outside work hours, off the employer's premises, and without use of the employer's equipment or other property." Right? So this is an exception to the normal at-will rule, just like anti-discrimination laws are an exception. So even though you're an at-will employee, for example, you can't be fired under New York state and federal law because of your gender, because of your race, because of your religion. So this is an exception to that rule. And the question in our case is, did it apply? Well, to determine whether it applies, what we need to do is figure out if there was a recreational activity to start. So what is that? The statute says that recreational activities mean any lawful leisure time activity for which the employee receives no compensation and which is generally engaged in for recreational purposes, including but not limited to sports, games, hobbies, exercise, reading, and the viewing of television, movies, and similar material. So the exemplar activities, again, sports, games, hobbies, exercise, reading, and the viewing of television, movies, and similar material. There is an exception in the law. If you engage in lawful recreational activities, we saw that you can't be fired because of that. But the exception comes in when your activities materially conflict with an employer's proprietary or business interest. So again, the baseline is you can't be fired for your recreational activities, generally speaking, but if those activities conflict with a proprietary or business interest, you can be fired for that. All right, so that's the recreational activities law. That was Sanders' claim. We argued that that didn't apply, and we also argued that her claims couldn't succeed under a doctrine called the ministerial exception. This is an affirmative defense, and we ended up winning in the Court of Appeals on this issue, and we can talk about questions surrounding that. But for now, let me just talk through what it is. So this is the First Amendment. Congress will make no law respecting an establishment of religion or prohibiting the free exercise thereof. So these are the Establishment Clause and the Free Exercise Clause. For many years, courts of appeals had read these to provide a certain protection for what are called ministers. And we'll get to that in a little bit. And under this doctrine, the ministerial exception, ministers had a special employment protection. So the normal rules, normal anti-discrimination provisions, for example, did not apply to ministers. So for example, a minister could be fired for a reason that might normally violate Title VII or one of the anti-discrimination laws. And if that provision was raised by the minister said, you violated my rights under this federal law, this state law, the response is, well, no, those laws don't apply to you. They're trumped by the First Amendment. The Supreme Court recognized this doctrine for the first time not too long ago. It was 2012 in a case called Hosanna Tabor, and then they followed up with a case called Our Lady of Guadalupe in 2020. And I want to talk a little bit about those cases. So this is from Hosanna Tabor. The First Amendment bars the government from interfering with the decision of a religious group to fire one of its ministers. Quote, by imposing an unwanted minister, the state infringes the Free Exercise Clause, which protects a religious group's right to shape its own faith and mission through its appointment, end quote. All right, so what's going on here is as follows. Let me talk about it in terms of the education context. So if we have the freedom of religion, if that means anything, it means that we have the freedom to practice our religion and pass along our religion and our brand of the religion to our children. And so we can have congregations and we can have religious schools, and those schools can teach the version of religion that we want without state interference. When you have a religious school teacher, they are teaching certain doctrine or conveying certain message. The identity of the person, you might say, also conveys sort of religion or information or a message. So if a religious institution has a religious educator who isn't living the values of the religious institution, the view is, well, that person's acts are educating the kids and not in a way that the religious institution wants. So the who of a teacher in a religious school is in a way coextensive with the what. What is the religion teaching? And so to the extent that the state can be involved in deciding whether or not a congregation can fire a teacher, the state is going to be, in a way, interfering with the transmission of religion in that congregation. And so what the courts have told us is under the First Amendment, when there's a claim for discrimination in terms of a firing, the normal laws just don't apply. The courts are not going to be involved. The congregation is going to have discretion to do it. And the discretion is broad. So this is, quote, "The purpose of the exception is not to safeguard a church's decision to fire a minister only when it is made for a religious reason. The exception instead ensures that the authority to select and control who will minister to the faithful, a matter strictly ecclesiastical," end quote, "is the church's alone." Quote, obviously, this doesn't just apply to churches, it would apply to synagogues and mosques and other religious institutions. The point here is that the exception sweeps broadly. It's not just cases where a religious institution fires someone for a religious reason that the courts say we're not going to get involved. Regardless of the reason, the courts say we are not going to get involved. So what happened in Hosanna Tabor, there was a teacher in a Lutheran elementary school. She was a called teacher. She had gotten a diploma giving her a title Minister of Religion Commission. She taught fourth grade secular subjects and religious subjects. She led students in prayer. At a certain point, she developed narcolepsy. She was asked to resign, and she threatened to sue. The school fired her. They said the reason they were firing her is because her threat violated church doctrine, saying that disputes needed to be handled internally. So the EOC brought a retaliation claim against the school. The Supreme Court found for the school. They said that the ministerial exception exists. They recognize that it's a doctrine, but they said there wasn't going to be a rigid formula. They said that the teacher qualified as a minister, and so the exception applied because she had this title, Minister of Religion Commission. The title reflected a significant degree of religious training. She held herself out as a minister by claiming a tax deduction for ministers, and her duties reflected a role in conveying the church's message and carrying out its mission. The court also said that the exception didn't have a stopwatch test. So to figure out whether or not you're a minister, you don't just look at whether or not somebody is doing these activities for a short amount of time or a long amount of time. You don't measure it by a stopwatch. All right, so the court gave us these four factors to consider in Hosanna Tabor. There was concurrence by Justice Thomas and another concurrence by Justice Alito. In Justice Alito's concurrence, he said that the exception should be much broader, that it really should go beyond these four factors. Well, some years later, the court took up this case, Our Lady of Guadalupe. Justice Alito, who wrote the concurrence in Hosanna Tabor, wrote the majority opinion in this case. And what happened there? There were two plaintiffs, lay elementary school teachers in Catholic schools. They taught secular and religious subjects. They took children to mass and they prayed with them. They asserted age and disability discrimination claims when their contracts weren't renewed. And so what happened? The Supreme Court found in favor of the school. It said that there was not going to be a necessary or sufficient condition to apply the ministerial exception. And Justice Alito, who wrote the concurrence in Hosanna Tabor, essentially took that concurrence and made it the majority in Our Lady of Guadalupe. So we went from a situation where we had these four factors to consider to a test that said that a minister includes anyone who leads a religious organization, conducts worship services or important religious ceremonies or rituals, or serves as a messenger or teacher of its faith. So that is a very broad presentation. And in fact, Justice Sotomayor, writing in dissent, criticized this first because she said, I thought we did not adopt this in our last case. This was just a concurrence. Now it's the majority. And she said this sweeps way too broadly and is going to immunize conduct with respect to a large number of religious employees who won't be able to assert things like discrimination claims. All right, so that is the ministerial exception. Let me now go to the lawsuit. You understand in very broad strokes what happened. Sandra was hired at WRT, and then she posted this blog. After she was hired and before she started work, she is then fired. So I want to focus in on how her lawyer pled the case. And I want to talk about a couple things that were very deliberate choices on their part. Here's the complaint. It was filed January 25th, 2022 in the Supreme Court of New York, Westchester County, which is right outside my window. I'm looking at it now. The case was brought by Herbst Law PLC. Bob Herbst was the lead lawyer for Sander. At paragraph 11 of the complaint, what they allege, and we moved to dismiss ultimately. So generally on a motion to dismiss, allegations are taken as true by the courts. They alleged that Sanders' job was secular rather than religious. They obviously did that because they were concerned about a ministerial exception challenge. They said the job was secular rather than religious. No religious ordination or training was required. They said the teaching responsibilities were essentially limited to the teaching and tutoring of the Hebrew language to WRT's learners and students. So that's why I showed you her job offer. We thought that was simply not true. In the complaint, they refer to her also as a full-time educator. She was, as you saw in the offer letter, a full-time Jewish educator. And the reason that they pled otherwise was to try to make it out that she was a secular teacher. We always thought not only was that not true, but it didn't make sense. This isn't a sort of school like we had in the Supreme Court cases where you had regular K through 12 schools where you had people who were teaching math and teaching probably geography and all sorts of secular subjects. This was a religious school. It was an adjunct to a synagogue. The whole purpose, and really the only purpose, was religious teaching. All right, so they pled that she was secular. And then they also talked about WRT's position on Zionism. So this matters because of the material conflict issue, which I talked about previously. They wanted to say that the position of the synagogue was either anti-Zionist or was non-existent. There was no position. But some of their allegations didn't work with that kind of a claim. And we focused on that in the case. So this is paragraphs 19 and 20 of the complaint. They say that in 2021, Sander was invited to a Zoom meeting with Rabbi Levy and Block. After a few minutes, Rabbi Levy told Sander he had an awkward question to ask. He said that he had read a May 20th, 2021 blog post on her website and asked if she understood that WRT was a Zionist institution and how comfortable she felt working at a Zionist institution as an anti-Zionist. She responded that she understood the political position of WRT. So we focused on these provisions because they constitute an acknowledgement that the synagogue was a Zionist institution. So she pled those two things. She also tried to, I'd say, muddy the waters by pleading additional claims. She focused on the synagogue's inclusiveness. It is a very inclusive place. But she said that this is paragraph 44, WRT doesn't require any adherence to any particular political point of view about Zionism, the Palestinians, or Israel's policy towards the Palestinians. She talked about Rabbi Blake and some of his sermons where he criticized aspects of the Israeli government. She did not cite any statements, because they don't exist, that Rabbi Blake thinks Israel should not be a Jewish state. That is a fundamental belief that regardless of whether or not the choice of any government is good, bad, or other, Israel's properly a Jewish state. But she put in her complaint a lot of statements that were critical of the Israeli government. She pled the single cause of action under the New York labor law, the recreational activities law, as we talked about earlier, and she filed the complaint. After she filed the complaint, we moved to dismiss. So what we argued was that if you accept the facts that she pled as true, for the most part, and you consider the offer letter and the blog, and you don't accept any of her conclusory assertions, things that she just said that aren't backed up, then we win. WRT wins the case. So what were our arguments? I want to go through them now. So these are arguments we made at the different levels, but I want to just summarize them here. So first, the question was she engaging in a recreational activity? Was she engaging in recreation? So what she said, Sanders said, is that, yeah, I was engaging in a recreational activity, blogging. She said blogging is done by, I don't know, thousands, millions, whatever, many, many people all the time for recreation. She said that if you look at the definition, which doesn't reference recreation, but does reference reading and watching TV and movies, she said that blogging was similar to those things. So blogging fell under the definition of a recreational activity. And she cited legislative history. In particular, there was a comment in the legislative history, which was sparse, that this bill will ensure that employers do not tell us how to think and play on her own time. So those were her arguments about recreation. We said she was not engaging in recreation. So first of all, we said was that what she was doing was a protest, which isn't recreational. There was a case that was on point. It was from the federal courts that talked about someone picketing outside of a company. And what we said was this is, while on the internet, no different from someone standing outside a company and picketing. It's just, it was a protest. We said that the nature of the blog meant it could not be recreational. She was calling for the destruction of Israel as a Jewish state. She kept referring to it as Israel, with the lowercase I. And what she said in her blog was not that she was engaging in some kind of recreation, leisure, some kind of fun activity. She told us that what she was doing when she posted her blog was a matter of life and death. She said it implicated, the she talked about the American-Israeli military-industrial complex. She basically said lives hinge on how America approaches Israel. And she said her project, in terms of making mensches and the blog, was emet, tikkun olam, and justice. So if anything is not recreational, we said it is those things, right? So those were the arguments on recreation, and I'm happy to talk more about that in the question and answer. We also said that even if she was engaging in a recreation, she wasn't fired because of her recreation. The synagogue was not anti-blogging. The synagogue really couldn't care less if she blogged or handed out pamphlets or wrote in crayon or whatever. Doesn't matter. They didn't care about that. What we say she alleges she was fired because of was her viewpoint. So the law 201D, the recreational activities law, doesn't say anything about viewpoints. Because of that, the other side had to read that in. They said that when the law protected activities, what it meant to do was to protect viewpoints. And they said since it protected viewpoints and she was fired because of her viewpoints, the law applied. So their argument was recreational activities includes reading, watching TV and movies. And what they said was, why would anybody fire an employee just because they read a book? Their view is the legislature, by listing those things as examples, must have meant to protect not just the act of reading or watching TV, but must have meant to protect the employee's viewpoint. So that was their argument. And our response was, no, the statute doesn't protect viewpoints. It could have, it doesn't. And so when you look at the plain language, it talks about activities, not viewpoints. So that's one reason it doesn't protect viewpoints. We also talked about canons of construction. These are principles that courts use to figure out what statutes mean. And so there's a canon that says that statutes that are in derogation of the common law need to be read narrowly. So this statute went against the common law because the common law was at-will employment. It narrowed effectively at-will employment. And we said, if there's a choice between reading it narrowly, as we did, or reading it broadly as they did to encompass viewpoints, you have to choose the narrow path. And then there was another canon called adjustum generis, which basically says when you have things in a list and you try to figure out what other things belong, you look at what's common to the things in the list. And here we said viewpoints were not common to those things because, for example, reading, exercise, and hobbies, don't necessarily have a viewpoint. All right, so those were arguments we made, and then we also had an argument about material conflict. I talked about this earlier. Our view was she pled that the synagogue was Zionist. Her blog was very explicitly anti-Zionist. And so even if she was otherwise covered by the statute, we would win under the material conflict provision. And their response was essentially, Rabbi Levy said he agreed with 90% of what she was saying. It's a quote. He never said, I agree with anti-Zionism, that Israel should not be a Jewish state. So we had arguments about the statute and material conflict, and we also argued the ministerial exception. We said that all you need to do is look at the offer letter. She's a full-time Jewish educator, not a full-time educator. She had religious job duties, pre-Bima tutoring, a weekly parsha. She was engaging in social justice. You can't say that social justice being taught in a religious school is some body of instruction separate from religion. That's obviously imbued with religious principles. And their argument here was that this ministerial exception was an affirmative defense and you needed to take discovery about whether or not it should apply. All right, so those were the legal arguments. And this brings us to the first decision. So the Supreme Court in Westchester granted our motion. They said that Sander had not stated a claim under the law. And the reason was as follows. The court wrote, the complaint plainly alleges that defendants terminated plaintiff from her employment at their religious school as a result of the content underlined of a message she posted to an online blog. The assertion that they terminated her for the simple act of participating in the recreational activity of blogging is a bare legal conclusion which we don't need to accept. So that was really the sum and substance of the trial court's opinion. They didn't reach the ministerial exception, nothing about the First Amendment, and they didn't reach material conflict. After the Supreme Court ruled, the other side appealed, and the Second Department, which is the New York Intermediate Appellate Court, affirmed the case. They sit mostly in Brooklyn. They actually have a courtroom in our building here in Westchester, but unfortunately I couldn't get them to allow me to argue here. We argued in Brooklyn, and we won that as well. The Second Department held as follows: even assuming without deciding that blogging is a protected recreational activity under Labor Law 201D, the complaint alleges the plaintiff was discharged not for the activity of blogging, but for the content of the post. We agree with the Supreme Court that the plaintiff was not discharged due to a protected recreational activity within the scope of the labor law. All right, so that was our first appeal. That was in the Second Department, and we were obviously very happy when we got that decision. The other side then sought leave from the New York Court of Appeals. The New York Court of Appeals takes very few cases, and we had hoped it wouldn't take this one, because if it denied leave, then we would have just won. But the court did take the case, and I went and argued at the court, which is in Albany. It's this really stately, gorgeous courtroom. You can see there are 7 seats for 7 judges, and when you deliver argument, you stand up close. There's a fireplace off to the left that you can't see, but it's just a grand room. And we had argument. We got a decision pretty quickly. We won, and we won 7-0, but the judges didn't all agree on why. So here's the opinion. The majority, we got 5 out of 7 votes on the ministerial exception, which was not what we had expected. Neither of the 2 lower courts had ruled on that principle. And we thought that the reason that the court had taken up the case was to explain this recreational activities law, which it had not done previously. The court chose not to do that, and they held as follows. They said that the descriptions, the job description that we all looked at, established that her core responsibilities as a teacher of religion are similar to those in Hosanna Tabor and Our Lady of Guadalupe. She was responsible for teaching religious texts through one-on-one study and weekly Torah portions. These duties leave little doubt she was charged with educating young people in their faith. Although she counters that her responsibilities were secular rather than religious, that allegation is conclusory. They said, we acknowledge the ministerial exception presents a fact-intensive question, generally not amenable to resolution on a motion to dismiss, but plaintiff worked in her position for less than 3 weeks, and discovery is therefore unlikely to yield additional facts about her job responsibilities. In these circumstances, the offer letter alone conclusively establishes the ministerial exception applies. Right, so that was the Court of Appeals. That was 5 of them. There was a concurrence from Judge Rivera, and that only got 1 vote. She ruled on material conflict, and what she said was, there is a doctrine of constitutional avoidance. When we can avoid ruling on a constitutional ground, that's what we have to do. And so she said, we, the court didn't need to reach the ministerial exception in the First Amendment because we had a pretty straightforward ruling on material conflict. She said, look, they pled that the synagogue was Zionist, her blog is anti-Zionist, that's all you need. And then there was one more concurrence from Judge Troutman, and she didn't write an opinion, but she concurred for the reasons that were given by the appellate division. So by the second department, which is the decision I read a little while ago, essentially agreeing on the recreational activities argument. All right, so that was our case. It took many years, and it is now done. It was a great case. I don't know if I'll ever get such a wonderful case again. And I'd be happy to answer any questions that people have.
Thank you so much, Michael. So that was very interesting, insightful. We definitely learned a great deal. So I'm going to open it up for questions. So if you would like to ask something, you can also use the raise hand function, or you can just unmute yourselves to talk, because it's not too many of us. So I think we can just have kind of an informal conversation. So let me see. Let's see. I think we are still processing. Sorry, Michael, did you let us know how you actually got the case?
No, I didn't. So we got the case because we are in Westchester and we're well known in Westchester, and members of the congregation, which is in Scarsdale, knew of our firm. And so we connected with them and worked with these members of the congregation who were really, really fantastic and were terrific partners with us on the case.
So I think it's really interesting because, one reason that I think that it's great to highlight cases like yours is that it's not necessarily what you specialize in. We have a lot of groups like Brandeis Center and Lawfare, and NJAC, who really specialize in these cases. But what we try to do by highlighting other cases is show people that, in any practice, you can really, and especially employment practices, you can really find a way to get involved in these types of cases. And especially if you're kind of on the lookout, sometimes you just need to know what kind of legal issues you need to identify when somebody comes to you. There's so many ways.
Yeah, I'll just say, one of the great things about our practice is that we're generalists, and everybody's got lots of training that lets you do generalist work at a high level. I do a lot of employment cases, but we do all sorts of cases. And it was great that we were able to defend the synagogue, in our backyard. And we were able to get up to speed, really quickly. This is not a law that comes up very often, and same with the First Amendment. But, we were able to get our hands around the law and marshal like a very good defense. I see there's a question. Jonathan Lipschitz. Hi,
Yes. Hey, Jonathan.
Hi, Michael. Thank you for your presentation.
thank you.
I'm an attorney and I'm working with the New Jersey Jewish Bar. And I'm working on a case in a place of public accommodation. Um, a trainer made like anti-Zionist remarks that sort of like curled over into religion a little bit. I know the IHRA definition isn't incorporated into New Jersey, but can anti-Zionism be considered anti-Semitism for like a law against discrimination case?
So under the New Jersey law,
Yeah.
I don't know the answer. I mean, I know that law is very broad. Like that's one of the more broad employment provisions. And I don't see why it couldn't be. I think it would have to be pretty fact intensive. I don't think you'd be able to just get a necessary connection between one and the other, but I think it could be done. That just sitting here today without knowing any of the case law. That's my sense. But yeah, maybe we can follow up after.
Yeah, sorry for putting you on the spot. I'd really like the opportunity to follow up with you.
Sure.
Should I LinkedIn you or how should I reach
Yeah,
out?
you just send me an email. Anybody can email me. I'm Michael@Yankwit.com. You can find me on LinkedIn or on our website. And yeah,
I can put it in the chat if you'd like, Michael.
sure. Yeah, that'd be great.
Yes, please.
Um,
Nice to meet you.
sorry, one T or two T's? Two T's. Okay. Um, yeah, that's conflation of anti-Zionism and anti-Semitism is obviously it's a big issue that has been recently decided. There was an unfavorable decision recently in the Second Circuit, I believe, and it continues to be litigated and decided. But those are generally more Title VI cases often. So there was no involvement at all here with Title VI.
No, no, this is just the single state law claim. That was it. Yeah, and the case was not really, I would say, about the recreational activities law. Obviously, that was what was pled, but this, like to my mind, I'm only speaking for myself, was sort of a way for this plaintiff to maybe spread her message or attack the Zionist philosophy. This was not a case, I think, about money. And obviously, there was no real expectation that she would want to return to this synagogue. But this was sort of a tool that she could use to further her advocacy. And, that's one of the reasons why I think we should have won, because this wasn't just recreation. What she was doing at all times, either, in the blog and after, was trying to get her message out. And, people will decide whether or not that was an appropriate way to do it through litigation. I mean, she certainly had the right to file her case. Not that it was meritorious, but I guess that's for others to decide.
Absolutely. And Michael, so it does seem obviously the court left open whether blogging or public expression is protected, right? Under is it 201D?
Yeah. So that's an open question still in New York. I mean, we have some authority from the intermediate appellate courts, but not very much. A lot of the jurisprudence was actually about dating and whether dating constituted a recreational activity. So, very different circumstance.
Yes. And so it looks like, so Gary Starr, he wrote as a caveat, some institutions include a process that must be followed before termination that can trump at will language. It's important for institutions follow their process or not include such language in a handbook. So that is more of a helpful statement than a question, but I think it does lead to the broader kind of practical implications on both employer and employer and employee sides in terms of how, on one hand, what should the employers take away from this decision, especially when they're drafting, say, describe job descriptions or offer letters. Here seems that the job description really helped them, and then on the other side, what do employees who are working in religious institutions need to know about the scope of their legal protections?
Yeah, it's a very good question, and thank you for the comment. So employees who perform religious functions at religious institutions are in a very tough spot, at least with respect to the employment laws, because the religious institutions have this enormous amount of discretion in terms of being able to fire them. And so, yes, it's certainly great advice that an institution should have policies and a handbook. But in a situation like ours, that would not have mattered, because regardless of whether they followed policies or not, the anti-discrimination laws didn't apply. The recreational activities law didn't apply, is what the court said, because of the First Amendment. And so you can imagine a situation where somebody maybe brings a breach of contract claim if you could get a handbook to be construed as a contract. But it's not clear to me that that would succeed, like for the same First Amendment reasons. And I didn't get into this in my remarks, but the ministerial exception is interpreted, it's a broad doctrine, and it's been interpreted very broadly. There are cases, I just pulled one this morning, where this is a Southern District case, Southern District of New York, and they reference a Judge Posner decision where he said that the ministerial exception applied to wage and hour claims. And what Judge Posner said was that a court applying the FLSA to a minister would inevitably entertain arguments that would plunge a court deep into religious controversy in church management, such as whether a vow of poverty was passé, or whether the facilitating of alms was commercial activity. So, if the ministerial exception applies to wage and hour claims, it is a very broad doctrine. There was a case recently in the intermediate appellate courts in New York about whether it applied to hostile work environment claims. And there the court said no. But I don't know if this goes up, that issue went up to the Supreme Court of the United States, we might get a different ruling. Just a very broad doctrine. And that means that these employees do not have the protections that lots of other employees do. And maybe that's a good thing, and maybe it isn't. I think the majority in the Supreme Court cases thought it was a very good thing, and the dissent, like Justice Sotomayor in particular, thought it wasn't.
Yeah, I think that there are just a lot of implications for us all to consider and to see, where this goes next. But the ministerial exception is a great one because it looks like they're positive. Obviously, this is a really positive outcome where there have not been as many positive outcomes as we would like to see, especially in Title VI claims.
Yeah, and I would just say, from kind of a general, just neutral legal point of view, we certainly think the court ruled correctly, and we were really happy that it ruled as it did. But the argument that we made is a totally neutral argument. And if Sander wants to go work at an anti-Zionist congregation, and somebody there wants to post a Zionist, blog post, they can do the same thing. So, really the legal principle is that people in religious institutions should be free to have an institution that follows their views, like whatever those views are. And if you have different views, the way to address that is not to bring a lawsuit. It's to go and publish more blogs or do your own advocacy or do whatever. But the law is going to have you do that work, and the law is not going to do the work for you.
Yes, no, I agree. And all right, so if nobody does not look like we have any more questions, but you might have a.
Sorry, one last thing.
Oh,
Michael, I sent you an email and a LinkedIn invite. I just want to make sure I'm not in like your spam folder.
Okay. All right. I'll follow up. That's great. Yeah. And if anybody else wants to reach out to me after the talk, I'd love to meet people. As I said, I'm new to the group, and I went to a talk previously. It was fantastic. I think the programming here is at a very high level, and so I'm looking forward to meeting new people in the group.
absolutely. Thanks so much, Michael, for such a thoughtful discussion. We learned so much, and there are definitely a lot of broader implications for us to consider. So wrapping up, if you are not yet part of the AAJLJ, we encourage you to join us. Of course, we are a growing community of lawyers engaged in a lot of meaningful work. And we are always looking to build and strengthen those connections. Also, this Sunday, we will be having our annual meeting, and we would love to see you all there. And as Michael actually had, reached out to, I believe, Arthur Traldi and got involved in that way, as a member. And we really welcome that kind of engagement for our members. If you have ideas, initiatives, if you want to present a webinar, please don't hesitate to reach out to me. We want to highlight the excellent work of our members and make sure that we create opportunities for collaboration. And again, wishing everyone a Zis Pesach and a meaningful holiday. Thank you so much to everyone for being with us today. And again, thank you, Michael.
Sure, it's a pleasure. All
Yeah.
right, thanks.
Bye-bye. Take care.